raise your right hand, please, ma'am. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, thank you very much. And Ms. Sellers, we've got your submissions that you have given to us. We've got your affidavit, and I think we've received copies of these exhibits. So every member has been distributed one of those copies. So just so you know, we've received those and we reviewed them. Okay, so we're happy to hear from you.
Sure, sir. I'd like to give.
You can speak in the microphone for us. Is it on? Yeah. Sorry.
I'd like to pass this up maybe through Lindy. This is a picture of my children and myself, and then a note this morning that was left on my laptop for my daughter. And as she's passing those, I prepared a statement overnight last night. Obviously, as you all probably know, this is a very anxious time for us as complainants. I would like to begin by genuinely thanking each of you for attending today. I know the task of attending these types of hearings are quite demanding and daunting. However, I would like to share that I've patiently waited for this day, for this time, in this public hearing for over 2 years. Some of you in this courtroom and on this commission have heard my story, and some of you have not. I have not had the pleasure of meeting. However, I would like for you to have an understanding of why I've traveled 3.5 hours back to Columbia today to address the lack of ethical fitness of Ms. Dunbar and why I take this so seriously. Please know and understand that I'm not here as a scorned litigant. Let me repeat, I'm not here as a scorned litigant. I am here as a constituent, a lay guardian ad litem, a concerned parent, and above all else, an advocate for 2 victims, my children. This is a very difficult position to be in because I'm standing before the very commission that South Carolina entrusted 4 years ago to find the most competent candidate for the 13th Judicial Circuit. But unfortunately, that chosen candidate failed me, failed my children, and the state of South Carolina. After reviewing the judicial applications and summary for the vote selecting Ms. Dunbar, I am concerned, deeply and severely concerned. I am eloquently pleading that each of you really hear and feel the ramifications, those being financial, emotional, physical, and the list goes on, that myself and Sandy have endured based on the lack of competence and ethical fitness that Ms. Dunbar displayed during her tenure as a family court judge for the 13th Judicial Circuit. We know there are thousands more, but they are scared, misinformed about this procedural process, or gave up waiting to be heard. However, 2 complaints, 2 in 1 day, for 1 candidate speaks volumes. As you all know what this took to get here. I mean, we all expect a judge to be as close to an example of perfection as we can get, correct? Well, please know I personally am not requesting that the bar is set for perfection, but I am, however, setting a standard and expectation that we as constituents, citizens, and litigants in South Carolina demand the following: respect, compassion, intelligence, experience, competence, and above all else, integrity. We are one of 2 states left out of 50 that are electing our judges in this manner.
Amen.
Please know we are watching intently as you yourselves are elected as the liaison to speak on our behalf. A majority of you sitting before me are elected officials and also private attorneys. No one is faulting you for making a living, but you yourselves know this is where the pavement turns to gravel road, and the perception is very much our reality as private litigants. I invite you to listen to the cliff notes of my case as I tell our story so you can understand why I have submitted the questions that I have for Ms. Dunbar to answer this afternoon. Since most of you before me are legal counsel, I challenge you to listen to my summary and timeline of events as if you were yourself wearing the hat as my legal counsel during this time frame. I believe that you will find that most enlightening and beneficial for your determination. The history of my case. I was married in 2006 to 2014 to a police officer out of Myrtle Beach. We had 2 children. They're both now 8 and 11. The father is a local police officer in the Greenville area, and I was a district manager for Walmart. I was recruited into management at 19 years old. I provided a bedroom, a 3-bedroom home with bedrooms for both children along with their own bathroom, and Dad provided a 1-bedroom apartment and allowed the children to sleep on the floor during their visitation a week at a time. Over the course of the divorce, the father repeatedly stalked me and harassed me. The chief of police at that time wouldn't investigate the formal complaint, as he was personally being investigated and potentially being indicted. I was covering, at the time, 17 Walmarts, had 2 small children, and lived on a 5-acre horse farm, all of which I maintained on my own. I subsequently asked to step down from my position to something that was more localized during my divorce due to the stressful and contentious nature of the litigation. Walmart agreed, but explained that after the divorce was finalized that they wanted me to move back up into my position. I mediated that case, and we found it was 50-50 placement and 50-50 custody. 1 week was with Mom and 1 week was with Dad. No alimony or child support was awarded. However, due to me being the breadwinner, I paid all daycare expenses and healthcare premiums. After the divorce concluded, I started interviewing for advancement opportunities, and due to the ethical contradictions, Home Office wouldn't allow me to move back up into my position in the Greenville area. I then filed a motion as a suggestion from Walmart to move to the Columbia area to maintain the financial support for my children, as I was the only party doing so. I won the motion and was granted the ability to move with the children to Lexington immediately. I did not receive a dime of child support, even though it was asked for in the pleadings. I didn't receive any financial assistance, not even 1 red cent from Mr. Nichols during the time that the children stayed in my custody. And that was a second temporary hearing. The children attended the best elementary schools in the state in Lexington, maintained honor roll, and were actively involved in extracurricular activities. The children were thriving in my home, and they each had their own bedrooms and bathrooms. Over the course of that time, Mr. Nichols still maintained and stalked me and filed formal DSS complaints, which were immediately investigated and closed. The investigator showed up at my place of employment and interviewed me, a disruption to my work environment. Mr. Nichols then had a GPS tracker placed on my car while I was at work. A customer saw this being done and thought it was a bomb being placed on my car. The customer then immediately went into Walmart and notified us, not knowing what had been done. I asked for a formal leave of absence from Walmart due to panic attacks and the stress that I was under with the stalking that I was enduring at the time. Over the course of that leave of absence, I ended up intercepting and meeting a woman by the name of Deborah Russell. Deborah Russell was the attorney on this case and had asked me, I ended up working for her and leaving Walmart due to I wanted to make sure that I had an administrative schedule versus a Walmart schedule for my children. Over the course of that, she agreed to do the case for a quid pro quo, and we were leading up to that time frame. In October is when we had a hurricane here and late in the season, and Mr. Nichols, the father, who was a police officer, asked that if he could get the children back for that weekend. That was his weekend of visitation, but they were doing lane reversals and evacuations on a Wednesday. And so I agreed and allowed Mr. Nichols to have them early so he was able to have his visitation with the children. At that time, where this is important, is that I had my son put back on medicine for ADHD. I noticed when he was about 3 years old the symptoms because my brother suffered from it. I had him diagnosed, and Mr. Nichols pitched a fit about Brantley being on medicine. But when he was in my full custody, I went back to the pediatrician and they agreed that Brantley needed to be placed on medicine. Where this is relevant is in October when the hurricane happened, Brantley, I wasn't unable to go home and collect his medicine to send with him to his dad before the lane reversals happened, so he went 5 days without his medicine. I picked him back up on Sunday evening for him to start school back again on Monday. And during that time, when I picked him up, he was in excruciating pain. And I didn't know what was wrong. And I get him home, and he just couldn't tell me because he was 4 years old of what was happening. And I talked to Miss Russell the next morning, and as I was gonna be late for work handling this and getting him off to school, and she heard him in the excruciating pain screaming. And she said, Lindsay, what's wrong? Something's not right. And I said, yeah, ever since I picked him back up from Greenville, something's not right. And so I ended up taking him to the doctor, and Deborah, because there was a friendship formed at that time, she said, let me come by the house and just see, because she was a previous solicitor in Richland County. And when she did so, she came out, she was talking to my son, I was outside with my daughter. She then comes back into my kitchen white as a ghost and says, we have to notify Greenville County of something. And I said, well, what is it? She said, Brantley admitted that Dad had put something sour in his bottom, and you'll see that referenced in the affidavit. I didn't know what that meant. I was just a scared mother because I didn't know what was wrong with my son. I didn't see any signs of any abuse from my ex-husband in the past. We've both been good parents, didn't get along. We were going through a contentious divorce and custody case, obviously. But I never had any signs of any issues with him. So I didn't know what to do, and so she's the attorney, so I took her suggestion, and we had a pretrial conference in Greenville that was scheduled later on that week. So we attend, she notifies, Judge Alex Kinlaw was the administrative judge at the time that was hearing the pretrial conference. And he says, well, we're gonna put this on hold because we need to find out what's gonna happen. And so I had Miss Russell ended up putting an affidavit for Greenville County. They did an investigation, a forensic ARC investigation was done here in Columbia, and was found out that Brantley had a side effect due to the medicine that no one knew about because he was without it. So he had an impaction. And I think, to Dad's defense, that he may have given him an enema, but Dad fails to communicate with me, so I didn't know what that was. But where that's relevant is we go through the pretrial conference, we come back, Judge Kinlaw ends up sending down something and reschedules the pretrial conference for us to make a determination as to what happens next. And during that time frame, a motion was filed by Mr. Wes Metz, Doug's attorney, disqualifying my attorney because she had made herself a witness to the case. As you know, I'm a mom. I was in the middle of a catch-22 because if I didn't follow her advice and something was wrong and Brantley had endured abuse, I was a negligent mother. And then there was no other way around it. So outside of that, Judge Kinlaw ends up disqualifying Ms. Russell, and we're 3 weeks from trial. She files a motion to continue. We're in the 30-day time frame, and we're calling every attorney we can to have them on standby, but they're under protection because they're already on the docket to clear a court docket in December of that year. We called 28 attorneys. It came down to the point that a retired family court judge prepped me to be a pro se litigant for this case. I waited and waited and waited. Judge Kinlaw did not fail to tell us what the determination was on the motion to reconsider. So I'm in limbo up until a week and a half prior to this 3-day final hearing of custody of my 2 children. I get into the courtroom, and first thing that I ask for is that the courtroom is sequestered. She grants, Miss Dunbar grants that request. My second was to file a formal motion on the record for a continuance based off of counsel. Her response to me was that I knew that she couldn't do that. And the reason being is because Judge Kinlaw put in his order when he disqualified Ms. Russell that the case would not be continued based off of counsel. Well, I would love to know, Commission, how and what I was supposed to do. I had an attorney. I didn't have her taken away. Judge Kinlaw took her away because she was doing what she thought was right for my son. And so then I'm the one, and my children are the ones that are now victims of this case because I'm stuck in a courtroom pro se and unable to have counsel present. Now, where we believe that that's okay in the state of South Carolina is appalling. Then, on top of that, we start the case. I was able to have multiple things admitted in evidence. And I think I did an okay job as a pro se litigant. But, however, I don't feel like that the case was handled appropriately by Ms. Dunbar. And that's that's why we are here today, but I wanted you to know the background of what took place and why I was a pro se litigant. It was not because I wanted to be. It was because I was forced by the state of South Carolina to be. And so this case is under appeal. It goes to oral arguments sometime in the spring. And but what happens next, I don't know. But for here today, what I'm addressing is Judge Dunbar's personal biases that she placed on the record. ADHD in my household for my son has been a big, big, big controversy for a long time. Now I can say my son has been diagnosed again with the help of his father, and he's also been diagnosed with a second syndrome that affects him. He was held back in the first grade due to this because in our final order, Judge Dunbar wrote that the parents have 50-50 legal custody, but however, due to the impasse, that father has final say. Well, I can tell you that there's nothing in my court case that would allow her to make such a judgment call. I never did anything wrong. I've never been convicted of a crime. Never. I don't think Walmart would allow me to cover 17 of their stores with a criminal record or have that type of character flaw. I'm asking for you today to take a stance that you do the right thing. Yes, we are 2 of 50 states that are still electing our judges this way, but I promise you that's not the right way, but we can't cure that problem here right now immediately. But what I am asking you to do today is don't allow this to continue. A personal bias, a judge that is unethical and allows that to happen should not be allowed to be on a bar, to be a part of the USC Law School, to be continuously making decisions, permanent decisions, for our children. She failed me, she failed my children, and she failed the state of South Carolina. And I feel confident in you, after waiting 2 years, that you will finally take a stance today and make sure that she is not allowed to continue. Thank you.
Thank you, Ms. Sellers. If you'll stay there, please. Just to summarize your complaint, it alleges that Judge Dunbar interjected her personal beliefs in the case. It questions the soundness of the decisions that the court made. Ms. Sellers, I plan to ask you some questions about each of these allegations, and then the commission members may have questions of their own.
Sure.
Right. Mr. Chairman, for the record, we again note that the commission is focused on the 9 evaluative criteria and not relitigating any past proceedings. First, Ms. Sellers, is your case under seal?
No.
Thank you. Generally, this hearing was a 3-day hearing in December of 2016 regarding custody of your children as you lived in the Columbia area and your ex-husband lived in the Greenville area. Is that correct?
Yes, ma'am.
Ms. Sellers, you allege that Judge Dunbar spoke about her personal experience regarding ADHD at a point during the 3-day hearing. Is that correct?
Yes, ma'am.
You already mentioned that you were pro se during that time. And was the statement during a portion of the trial where you were questioning your mother about your son's health?
Correct.
And is your mother in the healthcare profession?
No, but my mother is a state employee and works at DJJ as an intensive supervision probation officer, and she is very aware of all of the mental disorders on the DSM-5.
And your mother's present here today?
Yes, ma'am.
Mr. Chairman, if for the commission's benefit, on review of the transcript during the testimony of Karen Sykes, the complainant's mother, correct? The court stated, so an objection was made by Mr. Metz. Can you explain who Mr. Metz was earlier?
Yes, he was my ex-husband's he's the opposing attorney, the only attorney.
Mr. Metz stated, objection, Your Honor, outside of her expertise, her being your mother, Karen Sykes, is that correct? She's asking for an expert opinion regarding an ADHD diagnosis, and the court stated, I don't know that anybody can, I don't know that I can tell if somebody has ADHD. I think children are active. My kids were in school, and the teacher wanted to say my son had ADHD, took him, and he got a test, and he wasn't ADHD, so I don't know. Kids are active. Kids don't get to play outside as much as they used to. I mean, I don't know. It's really a flipping science. to this whole ADHD, and I don't want to go into any testimony that I don't believe an individual can determine whether anybody has it. I mean, there's a controversy where some scientists are now saying that people are just making these diagnoses, and some are saying it's not ADHD, who knows. And then they got all kinds of varieties of ADHD. I mean, it seems like everybody that I see come in the courtroom, they got it. Every little boy, and the girls have it, but all the boys have it. And we can get some testimony from Ms. Mobley. She's a guardian ad litem. She probably can testify that every case she got on little boys, they got ADHD. So I don't want to hear any. I don't think she, and I'll sustain, I don't think she got the expertise to determine if anybody has ADHD. All right, go on. And then you began questioning your mother further.
So to
Is
clear,
that an accurate trail?
I just want to make sure that you're giving the dialogue from Judge Dunbar, is that correct?
When I said the court, yes. Is that an accurate trail?
Absolutely.
Ms. Sellers, you also allege that Judge Dunbar made reference to a personal experience when discussing the lack of bedrooms for your children at your ex-husband's apartment. Is that correct?
Yes, ma'am.
Do you know when during the trial this occurred? This discussion from the court regarding the bedrooms?
I can't, I mean, it was a 3-day trial, Ms. Dean.
Sure.
I honestly don't remember exactly. I can summarize it for you. I was contesting the fact that Mr. Nichols only provided a 1-bedroom apartment, and we had a 50-50, 1 week with mom, 1 week with dad. I provided 2 bedrooms and a bathroom for my children. He provided sleeping bags on the floor for them every other week. I'm sorry, but as a mom, I did not feel that that was in the best interest of my children. And then Mrs. Dunbar went on to elaborate that her children slept together in a full-size, I think it was a full-size bed for over a year while her house was being remodeled, and that she didn't see that there was any problem with that.
Okay, and on review of the transcript, would it be consistent with your recollection that the judge ruled and then you sought to do a closing argument, and then the court responded to your closing argument?
Yes, and I think I referenced, I think I even submitted an exhibits, the floor plans of my house, the pictures from the guardian ad litem, as well as the floor plans from his apartment of what the children were living in.
And is it consistent with your recollection that during this reply, so the court has already ruled, you've then made your closing statement, and then the court responded to your closing statement in part saying, yes, these children might have slept on an air mattress. I don't see any harm with that. My husband and I and my 3 children, 3 of them slept in the same bed, in a queen-size bed, and we were remodeling our house for over a year. I don't find any evidence that they were harmed in any way. People can grow closer. Yes, they might be better in a 3-bedroom, but I don't find that as a reason to allow them to move to Lexington just because they can have a 3-bedroom. Is that consistent with your recollection?
Yes, and I absolutely 110% disagree with that. I don't think, and would like to believe that every single one of you as commission members wouldn't allow your children or be okay with permanently allowing your children to sleep on an air mattress a week on and a week off. But yet, Ms. Dunbar is up here telling us that she has the best interests of South Carolina children at heart. I disagree.
And Ms. Sellers, you also allege that Judge Dunbar took breaks before ruling on issues, and you allege she spoke with other judges during these breaks. Would you like to address that matter?
She was consistently, well, first off, as I explained previously, when I went in and filed the formal motion on the record again to reiterate that I did not want to be a pro se litigant, that I wanted an attorney there. But however, I was prepared to continue to move forward. She was referencing, I believe, and I'll let her speak to that, that she said she couldn't allow that. Well, I believe that that was based off of Judge Alex Kinlaw's order where he wrote that in that order. Now, I am under the belief through going through that 3-day hearing that she was continuously getting up and going into chambers, taking breaks. And again, it's been over 2 years, but she was going back into chambers to research things and speak to people, and it was several times a day. And if you have a competent judge, we shouldn't be getting up off the bench and going and having to converse with fellow judges and fellow people in chambers. Sure, she can ask for a break, but that's not what's referenced in the transcripts.
Lastly, Ms. Sellers, you question the soundness of Judge Dunbar's decisions without relitigating your case. Could you please explain this concern?
Judge Dunbar, in her order, I submitted a financial declaration on what I thought, again, with me and a pro se litigant, what I thought was correct. It was incorrect, and she calculated child support based off of an incorrect number with me being a pro se litigant. It was my mistake. I will tell each and every one of you, I have paid for that dearly. I'm paying over $1,000 a month for 2 children and did that on a $32,000 salary. It is like I have been held at a ransom and a hell for 2 years based off of what Judge Dunbar did. She also put in her order that I pay $15,000 for the opposing counsel's legal fees within 90 days of her final order. I believe she referenced something to that effect of 90 days that dealt with an appellate case. I'm not sure if she was referencing mine because that is under appeal, but I don't know where she's getting the terminology from or thinks that it's okay for 90 days. And as a parent that provided financial documents, there was not $15,000 to be had in 90 days. And again, I'm no criminal, and I don't understand why that myself as a good involved parent would be up for potentially going to jail based off of her making such an erroneous ruling.
Thank you, Ms. Sellers. Thank you, Mr. Chairman.
Let me ask you one question. I'll start off if you don't mind. And I know you said, how long did Judge Kinlaw give you to hire an attorney before this?
That's why I'm here.
So when did you receive notice of the order that, I understood what you testified to earlier.
I'm sorry.
But if you testified earlier that he provided an order that said the matter could not be continued, is that correct?
And that was at the end, I believe the end of November. The hearing for this case was the middle of December. It was the 12th, 13th, 14th range of December. So I didn't even have 30 days. So we called and reached out to fellow attorneys. I was dating a public defender for 3 years at the time. He reached out to every attorney that he knew possible to try to get help for me. They were all protected because they were already on the docket and slated for court. They couldn't get to me. So then he reached out to a retired family court judge who prepped me for several hours and told me I was the best pro se litigant that he'd ever seen.
But in that regard, how long had this case been pending before this final
Oh,
hearing?
365. We were on the 365-day rule, which is fine. But again, I was prepared to move forward with my counsel, and he disqualified the counsel. It wasn't for any other reason.
Right, but he told you the hearing was going forward whether you had an attorney or not.
Well, actually, we weren't present for the hearing because that was at the time. I don't know if you remember. That was at the time that we had the South Carolina wildfires right after that hurricane. It was on the Ashland. Correct. And so all of the smoke and smog, we were 6 or 9 minutes late to the court hearing. She had called the admin to let them know. We walked to the courtroom and the hearing was already over. So during her disqualification hearing, we never even made it. We were never even allowed in the courtroom. He said he wouldn't talk to her. Judge Alex Kinlaw.
Representative Murphy.
Ms. Sellers, thank you for being here today, and I just wanted to follow up a little bit with what Representative Smith was asking. After the hearing where your attorney was disqualified, was a motion for reconsideration reconsideration
Yes,
filed.
a Rule 59 was submitted to Judge Kinlaw, and he kept it in abeyance and did not respond. She kept reaching out to his office trying to get a determination because she's still held as counsel, and I wasn't released to go obtain new counsel, even though we were trying to get attorneys on the phone. We called 28 different attorneys.
Was an order ever filed on that motion to reconsideration? Is that?
I think we got it, again, it's been a long time and I don't have the documents right in front of me. I do believe it was within like several days of the final hearing. It was not within a notice of like 10 days or anything where you could have even had the time to.
So there was a
to
ruling
obtain.
on the motion for reconsideration?
I wanna say it was within several days, yeah.
A few days prior to the final hearing?
Final hearing of final custody of my 2 children.
Thank you.
Senator Rankin.
Likewise, ma'am, I appreciate your being here. This is certainly not comfortable for you.
No, sir.
Obviously, by your demeanor, I'm trying to divine what's going on here. And I've been a family court litigant one time. Pray I'll never be again.
I'm sorry.
So that's not, thank God the system exists. Does it need to be improved? Can everything be improved? Certainly. What we have to do is work within the facts that you have in your case and others that are filming. My good friend, former neighbor here, and another fellow from Horry County, and others here that are looking for some reform, perhaps. Your case, though, as the first on the docket, I guess, of complaints that have been filed. Why, help me, why does Judge, and this is in your brief, your attorney's brief, your attorney is Brett Stevens?
Yes, sir.
Correct. Why does Judge Kinlaw grant the father's motion ordering the father's counsel to put some strong language in the order indicating that the case was not to be continued, quote, under any circumstances, end quote? What's going on with that? Help us.
Sir, I assure you, you probably don't want me to summarize that or make an opinion, but I will tell you my personal opinion, because we weren't allowed to be in that courtroom because he wouldn't even see her that day. She was 6 minutes late.
Your attorney was 6 minutes late getting to that hearing.
Yes, sir.
And so, again, there's a record, I assume. And that's not opinions, but is there a record that from Judge Kinlaw explains what you've included in your brief?
They're in the appeal that's been submitted. We did get the transcripts from that hearing that we weren't even allowed to go in the courtroom. We did get the transcripts and they were provided to the Court of Appeals.
Is that transcript sealed, or is that the
No,
transcript?
none of my documents in any case that I've had with this action have ever been sealed, and you're more than welcome to go obtain them.
So, not that your opinion doesn't count, but what is in the record that warrants that discussion under no circumstances? I mean, is there anything cited within that?
Absolutely nothing. I think that he was, my belief is that he was just agitated at the fact that she was late for court. But however, again, I mean, we were dealing with wildfires, the state was under a state of emergency, and she notified the court, letting them know that we were en route. We get there and she says, I'm here, and the bailiff's like, court case is already, done. It's amazing to me in 6 minutes that we've already finalized a case disqualifying my attorney on a final 3-day hearing. I have no words.
All right. Some allegation, again, you've mentioned with your child, medication. In your prior attorney overhearing something that ultimately did not rise to the level of a crime.
Correct.
There was an investigation of your husband?
Yes, see, my husband is an SRO at a middle school in Greenville County. And so when this arose, I'm sitting there as a mom at my house and she's looking at me like, oh my God, what do we do? I've got a child who's bleeding. I'm just gonna be graphic, I apologize, but he's bleeding from his rectum, doubled over in pain, and he's 4 years old and can't tell me why. But the only statement that we know at that point is Dad put something sour in his bottom.
And you have said to us, you give your ex-husband, the father, the benefit of the doubt.
I do. I think, you know, and we had all said that. I mean, I talked to my parents. I talked with, you know, my significant other at that time, and I had nothing to substantiate or even feel that Mr. Nichols had done anything like that of the sort. But again, what if I didn't follow through with what my attorney who is representing me tells me to do? And what if something did happen? Now who's negligent? Who's the parent that could be held accountable for that? Me. And he's around other children. So that's the way it's presented to me. And so she said, we just have to follow through. If nothing happens, nothing happens. But in no way was that to spin the court in a different direction. I mean, there's medical records proving that my son had an impaction at that time in his intestine. That's what was caused by that. So it's not something that's fabricated, you know, or fabricated on behalf of a private litigant trying to push a family court trial off, I assure you. It was my son was in pain, and when he says that at 4 and you have nothing else to go on, and the only thing that I would say that Mr. Nichols is guilty of is he doesn't communicate as a parent with me. So I didn't know that there was any problem with my child until he gets in the car and he's doubled over in pain.
So that red flag was raised and then lowered. That concern was.
Yes, Art here in Columbia, because we lived in Lexington, completed a forensic investigation and deemed that there was no fault at Mom's house or Dad's house. It was what it was, and at that time after the interview, he was already fine. It was just we realized that the medicine 10X causes issues with the intestine.
You all had litigated this case for a year. Did y'all do discovery, depositions of each
Yes.
other?
We didn't do depositions, there was discovery, went through mediation. Mediation with him is not successful.
You had an attorney at mediation.
Mm-hmm.
Yes.
Yes. We had attorneys up until that point. I mean, the only time that a pro se situation had happened during this custody action was when my attorney was taken away from me and I was unable to obtain another one. Was forced into the situation.
So your former attorney is the one who is now representing you in this
No, I will go ahead and let you know, there's been some serious unethical allegations about her, and I am turning over a 15-page document to the OVC. I have that here if you'd like to see
No,
it.
that's not. So you've got an appeal, there's a brief that another attorney has prepared. And has your ex-husband replied?
Responded, yes.
All right, and who is his attorney?
Wes Metz, he is the opposing attorney for this action as well as his appeal. I don't believe he has any experience in appellate court. That's why I hired Brent to be the attorney on that, because she had extensive appellate experience.
And you understand, again, rarely in family court, unless it's an adoption, does anyone walk out happy.
Absolutely.
When a marriage goes south, when a child's home is broken up, no one is happy. You agree with that? And I say that empathetic with you, because I've been there, I know that. But you do likewise understand that it is a call that a judge is given the discretion to make rightly or wrongly. And there's a process for that. You're not complaining about the appellate process. You're just complaining to us that it should never have gone to that point.
One, I should have never been forced into a situation without legal counsel, just to appease a docket of administratively making sure this didn't go into the next year's fiscal docket.
All right, and on that point, tell me about the exchange with Judge Dunbar in refusing that.
I'll let her speak to that, but the response to me when I formally put it on the record on day 1 is that she says, "Now, Ms. Sellers, you know I cannot do that." Why?
And what,
Were you told that you weren't allowed to do it?
so not what she's going to say, but what does the record say?
That's exactly what the record says. and is what's provided in the appeal.